These are non-contiguous excerpts from the book, Peeking Through Blind Justice, One Person's Fight Against Workplace Discrimination, to give you a peek at the book's actual contents. It is a big step to file a discrimination charge, especially when still working for the company. I did not take this decision lightly. When I reached the point of no return, when I witnessed two CEOs promoting others, giving others different positions and titles, and always bypassing me, I knew something was wrong. I was well qualified, educated, proven to be an exemplary employee, had extensive longevity with the organization, and was well liked and praised by our subscribers as well as my peers. I was also the only Jew ever employed in the organization. I took Title VII literally that no employer may discriminate in promoting employees. I was misled. At the start of filing with the EEOC, the Equal Employment Opportunity Commission, the employers afforded the opportunity to participate in mediation at no cost to settle the situation without further action of EEOC or federal court, an action highly advocated by both government institutions. In spite of the defense attorney claiming they were making an attempt to expedite the EEOC's investigation in this matter, my employer refused mediation and opted for hiring an attorney and prolonging the whole process. Approximately 140 days into my case, I asked my agent for a status update. He let me know he did not have any specifics on a time frame for going forward because he was working on priority cases and older cases. Then, 3 months later, there was a government shutdown. I was sure the shutdown would not help my case's ranking as a priority. My intent had always been to resolve this issue early on, but with the EEOC not moving forward on this and my company not making any attempt to discuss this with me, I decided to go another path after I determined a couple of profound reasons to move my case from agency to attorney. I received the news that the defendant's motion to dismiss was in large part denied. This is not a very unusual verdict, since it is typical that the plaintiff gets this win. In response to defense saying the majority of my claims involved Christmas-related activities, not religion, the court said this argument lacked merit. Title VII defines the term religion to include all aspects of religious observance and practice, as well as belief. The court agreed with me that a statement about the birth of Christ, crosses on the holiday party invitations, and song with lyrics, Christ our Lord, all contain an aspect of religious observance, practice, and belief. Recognizing anti-Semitism is less what you learn and more what you experience and live. When I was around 10 years old, I had my first close-up experience. The Jewish cemetery in a suburb of Chicago, where my maternal great-grandparents are buried, had been vandalized by Nazis. Many tombstones had writings saying all Jews will be found here. I remember that incident well. It was scary for a 10-year-old to hear this. After all, I was already learning the horrors of the Holocaust from friends and Sunday school teachers. The Diary of Anne Frank was on the bookshelf in my house, as well as on the shelves of others in my community. Ever since then, I always considered what would make a good hiding place. The hora, a dance, became an issue. One year, I sent an email to staff that I would teach the hora. Defense questioned me about this and also commented on it in summary judgment. My email stated it was a celebratory dance and did not equate it with Judaism at all. In my deposition, I mentioned it actually has its origin from other ethnic groups. The dance, having only 3 steps, jump, kick, and grapevine, is far from anything religious, and I am sure no one ever would be offended by it. In fact, my Zumba instructors often choreograph using some combination of those steps. Yes, they are rather universal. Would I have been questioned the same if I were instructing the salsa, or tango, or even breakdancing? Defense professed several times that the company was uninformed and blindsided, not their actual words, about my claim of discrimination and hostile work environment. It was their contention that the latter was revealed not until they were supplied the complaint, as well as not until they requested my file from EEOC after we responded to their motion to dismiss. They were concerned that neither I, the EEOC, nor anyone else told them previously about these allegations. I take exception to their querulous perception about not being told prior to litigation. They often refer to learning about the grievances as the first time. It doesn't matter when it was first disclosed. The time should not have offered any other action than to try to discuss it and remedy it immediately. Whether you are in HR or management, when someone comes to you with their issue, the first thing you want to do is quiet your mind. Open the necessary space inside you to listen fully and take in what the person in front of you is saying. Make a commitment to completely surrender to the person who is speaking and listen fully. Be quiet more than 90% of the time. Speak to ask a question for clarity or to make comments that encourage a speaker to continue. Listen because you know there is more for you to learn. Hold the person in front of you in high regard. Acknowledge the needs, perceptions, thoughts, and position of the person in front of you. Never act as if you know more than the person bringing you the issue. Abstain from evaluating, attacking, or judging. For each of you who has something to say, and you all do, speak. Stand up for your beliefs and your dreams. Question the rules and policies blessed by top brass. You always have the right to not only be treated the way you want, but to let people know when their actions are in direct opposition. Don't put up with behaviors that you don't like, no matter your level on the organizational chart. We all have the responsibility to start the process of helping each person become a mensch, a good, upstanding human being, and each of us has a responsibility of accepting help to become a mensch. Offer suggestions to improve the quality and scope of work at your company, even if your opinions are neither solicited nor encouraged. The book is in 3 parts. The first part is the legal process, the second part is bigotry and religion, and the third part is organizations and the general civility code. Do you think as an employee you are protected under the Title VII of the Civil Rights Act? The judicial system keeps the bar quite high for legal workplace discrimination. As long as the organization stays just below that bar, they can discriminate. And they do. Sharing her experience as a plaintiff in a federal religious discrimination case, Marcy Rich gives us a ground view of the winding process of litigation, starting with filing a charge with EEOC. By infusing her story with actual statements, testimonies, and documents, you get a glimpse of the maneuvering facts and data employed in the legal system. As she gives many examples of the biases and intolerances inflicted on her, she powerfully reminds us how each of us must make more inquiries about our differences than judgments. In peeking through blind justice, the discussion of the legal process makes way to show the responsibility organizations and their leadership have to enforce the general civility code.